Call roll, please. You may be seated. Thank you, Ed. Good morning, everyone. Oh, we're glad to be back. This is the first time for us, our court, to be back. We have a court in Liberal, and we have one in Wichita, and of course we have one here in Topeka. And this is the first time back since the security breach, and we're happy to be back and happy to have you here this morning. Before I get started, my name is Henry Green. I will be the presiding judge for our docket this morning. So the other judges are here with me, and to my right is Stephen H. Hill. We're lucky to be. Judge Hill is the longest serving judge or district court and the Court of Appeals judge in the state of Kansas. I think he shared with me he has been serving as a judge for at least 45 years. So I'm honored to be with him and to help us out. And to my left is Amy Fellows Klein, and she's a super attorney too. Okay, today we have 3 argued cases, and the first case that we have set for argument is 125858, and I like to get their appearing for the appellant. Mr. Hutchinson, do you want any rebuttal time? This is 15 minutes. 3 minutes. And appearing for the state, Mr. Obermeyer, right? Stephen J. Are you ready to present your arguments? Okay, we're ready to hear.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing this morning on behalf of Dewan Sweet. I would remind the court this is an aggravated burglary prosecution and aggravated assault out of Leavenworth County. There's a lot that's not disputed in this case. There's not disputed that my client went to an apartment in this case, that person in that apartment owed my client's money, and my client went there to get that money. There's a lot of disputes about exactly what my client's intent was when he went in there, whether he had criminal intent or whether he was there to get his money back and some things like that. My intent today is to focus mainly on the instructional issues and the sentencing issue presented in this case, and submit the other issues on the brief. I know this court may have different plans for me, and I'll be glad to address whatever the court is most interested in. So in this case, there are 2 instructional issues, both having to do with the failure to give a lesser included offense instruction. The first having to do with the fact that the district court in this case didn't give a lesser included offense of assault, simple assault, in a case where my client was charged with aggravated assault.
Is this a clear error standard?
It would be a clear error standard, Your Honor.
Okay.
And I don't think there's a lot of dispute that it would be legally appropriate to give assault as a lesser of aggravated assault. And I don't think there's a lot of dispute that it's factually appropriate, given the standard that the Supreme Court has put out. So yeah, I think there's error, but we move on to clear error. And it's where I wanted to address my comments mainly. I think it's interesting, Your Honors, as I sort of have been, as we've been litigating this idea of clear error of the last few years, sort of, and sort of getting some cases from our Supreme Court on this and questioning sort of whether they're changing clear error or whether, you know, in sort of in sports parlance, sometimes referees have points of emphasis sometimes that we're not changing the rules, but we're emphasizing certain rules in certain ways. And I'm not sure today what the Supreme Court, where they're sort of headed on this or what they're doing on this. But I'm going to believe today still that there is such a thing as clear error, that the Kansas Supreme Court didn't repeal the statute. And so I'm going to believe that there is still clear error today and that we can talk about that. Although it's harder and harder sometimes. I wonder, like, how do I show clear error given, and this court sometimes has described it as a high burden, to show clear error and things like that. But in this case, with regard to this particular issue, again, we're arguing that the district court should have given a lesser of assault in this prosecution for aggravated assault. We have a question from the jury asking for the definition of assault without a gun. That's simple assault.
When I read that, it struck me as something that the trial judge should have picked up on. There's no procedural bar to, after receiving an instruction, to a question from the jury. Is there a procedural bar to prevent the trial court from giving an instruction, just as you're suggesting, a lesser included on assault?
Absolutely not, Your Honor. I mean, that the judge could have said, oh, there is an accurate answer to that question. Yes, there is a crime called simple assault, and it's assault without a gun. Yeah, that's exactly right, jury.
Now, I assume I have not read through the transcript of the instruction conference. Was there discussion of giving this? Did the judge say, no, I'm not going to give that instruction? Was there any conference on that? Any suggestion during the instruction conference?
I don't remember any discussion of that, Your Honor. Certainly, we didn't request it, and we acknowledge that in our brief. And I don't remember any discussion of it particularly. We didn't object to it. And so that's why we're on the clear error standard. So, so we think, again, as I think about how difficult it may be in some cases, if I have to prove what the jury was thinking, that's going to be hard in a lot of cases. But I actually have in this record some evidence of what this jury was thinking about. And Your Honor, I wanted to particularly point out that error or reversibility can be even different between count and count. And so particularly in this case, because my colleague is sort of arguing that, well, it's not reversible with regard to the aggravated assault because it's sort of an all or nothing proposition. Either he used a gun and caused assault or he didn't do anything. And I disagree with that, but that's what it is. But with regard to the aggravated burglary in this case, Your Honor, I think it also is important that the reversibility analysis is different, because it's not about what the client actually did. It's what the client's intent was when the client went into the house. And so, for example, if the jury had been properly instructed about there's this thing called simple assault, and if even one juror formed a reasonable doubt and thought, well, maybe this person intended to go in to be intimidating to get money, which could be assault, but did he intend to use the gun? He had the gun. Did he intend to use it? And if he didn't, then that's only simple assault, intent to commit simple assault. That's not burglary in Kansas. Entry into a building or a structure without intent to commit one of the specified crimes isn't burglary. So I just want to point out, I think the reversibility analysis is even a little bit different between these, between the aggravated assault convictions and the aggravated burglary.
Counsel, what should we glean, if anything, from the jury's verdict in terms of the fact that they convicted your client of aggravated assault against only 3 of the witnesses and not the 4th? I mean, that seems discerning to me in terms of whether they believed your client that he didn't have a gun or didn't intend to use it. What should we take from that?
I mean, a couple of things. One, we should take that the jury didn't believe all of the state's evidence. And we cite that as part of our reasoning for why we think it is clear error in this case with regard to the aggravated assault convictions. And that, I mean, we can look at and try to dissect the evidence in some way to say, here's some of the differences between this, but we get into the speculation about what the jury, is sort of thinking in that regard. So all I can say that you can take from that is that the jury didn't believe everything that the state presented.
But aren't you asking us to speculate? I mean, to meet your clear error standard, you have to ask us to speculate that a different instruction would have impacted the verdict, correct?
It's not to speculate because, I mean, you have to base it on a record. And so the question is, in this record, is there a real possibility that the jury would have come back with a different verdict? And it's certainly with regard to the aggravated assault, we think and propose that the fact that the jury did acquit on one of the aggravated assault counts supports that if they had been properly instructed as they asked to be instructed, that they might have been different on one or more of those other counts as well. Your Honor, the second instructional issue, how am I doing on time, Your Honor?
You're doing pretty well. You got about 5 minutes left.
Maybe I'll skip to the sentencing issue and come back to the second instructional issue if I need to. I just want to make it really clear because there's some disagreement between my colleague and I on this. In this case, it is our belief that based on the amended information filed by the state, my client was not charged with burglary of a dwelling. Aggravated burglary of a dwelling is a severe level 4 offense. Burglary of a building, aggravated burglary of a different kind of building is a severe level 5 offense. The facts alleged in the state's amended information charge the crime of burglary of a building other than a dwelling. That's a severity level 5 offense, but my client was sentenced for a severity level 4 offense. And so my colleague is
They're instructed on the severity level 4 offense.
Yeah, that's right. But that's not what the state charged. And the state is bound by its charge. That probably was an instructional issue, Your Honor.
Everyone
Error.
argued. I mean, everyone seemed to argue that the apartment was a dwelling. I mean, it seems like all the arguments in the case were directed to the severity level 4 offense. The jury instructions were directed to that. I mean,
The
Can we
facts
find
were,
that-
there are facts to support that it was a dwelling. I mean, we're not arguing that. That's not the point. The point is the state didn't charge my client with that. And it's a due process violation and also a violation of our sentencing statutes to sentence somebody for a crime they're not charged with. My colleague is trying to make this into some sort of a defective complaint issue or something like that on my part. And Your Honor, I just want to make it really clear. That's not my argument. I think that this complaint charged a crime. Period. It charged burglary of something that wasn't a dwelling. And that being the case, the
remedy
sentence in
would
this,
then be vacate the sentence and remand for resentencing as a severity level 5.
if you otherwise affirm the conviction, yes. Yes, that's the remedy we're asking for on that. So I just wanted to make that really clear and see if there are any questions on that, because there was some disagreement about what kind of issue that was between my colleague and I.
Okay.
Is that my time, Your Honor?
Hey, you got 1 minute left. To keep your rebuttal.
I'll submit the rest on the brief, Your Honor.
Okay. Thank you very much. Mr. Obermeyer?
Good morning. May it please the court, the state appears by Stephen Obermeyer. I'm an assistant solicitor general. I'll address the issues, arguments in the same order unless you want to talk about a different.
Would you mind talking about the sentencing issue? Because that seems to be pretty clear here. Finally, Mr. Hodgkinson, in a quick way, explained to me what his argument was. And if I'm looking at this complaint, it seems to be that he has a valid reason for a complaint here. Because isn't it, I'm reading this, doesn't say a dwelling. It doesn't say a dwelling. What's your response to that?
My response to that is the complaint did erroneously charge burglary of a motor vehicle or a dwelling. The complaint also alleged that it was a severity level 4 felony. The complaint also cited the correct subsection for burglary of a dwelling, the severity level 4 subsection. The juror, he's essentially arguing, if this is a motion to correct sentence, that my conviction for burglary of a dwelling should be voided and find me guilty of burglary of a motor vehicle or a structure, even though the jury wasn't instructed on that. And in a motion to correct sentence.
Well, it's not an instructional error. He's arguing that your charge was defective and you can only convict somebody of what they're charged with. You can't sentence somebody to a crime that they weren't charged with. That's a due process violation. You agree?
If he was charged with a severity level 5 burglary,
Yeah.
I'm saying, but for the dwelling or motor vehicle or building language, that complaint charged burglary of a dwelling, a severity level 4 felony, and he can't sit and not say anything to the trial court and wait till this case gets up on appeal. And I would cite to the court KSA 22-3208 subsection 4, which says, a consent to trial upon a complaint shall constitute a waiver of defenses and objections based upon the institution of the prosecution or based upon defects in the complaint, which is what they're saying we have here, other than it fails to show jurisdiction in the court or to charge a crime. And that, I don't know how you can get around that statute. That I'm not going to say anything to the trial judge, not ask for any, not mention it to the instruction conference, but here we are in appeal.
Was there anything said about this post-conviction? I mean, after the verdict, was there any argument by the defense that, hey, we shouldn't be sentenced to a 4, we should be sentenced to a 5?
No, the issue was not presented to the trial court. It's like the cases where the instruction, jury instruction is broader than what's in the complaint. And I cite State versus Turbeville. And in those situations, the defendant's aware of what he was charged with and contested it on those grounds. And there was not a due process violation. Is our argument on that issue. With regard to the first, the failure to give an assault lesser, I would direct the court to the recent case of State versus Lowe. I miscited the volume that it's in the Kansas reports. It's in volume 317, Kansas, at page 713 is where that opinion is set out. And it does talk about the clearly erroneous standard in that this court has to be firmly convinced that the jury would have reached a different verdict if the instruction had been given. In the Lowe case, the court looked to what the defense evidence, what the defense theory was in deciding that a lesser of simple assault when a person's driving a car, swerving towards somebody, that was the ag assault. And the Lowe court said, yes, there should have been a simple assault instruction given, but it was not clearly erroneous not to have given it in the facts of that case. And under the facts of this case, the defense wasn't that I committed a simple assault. The defense was I had the gun in my pocket when I walked in, and knowing I was going to be in a fight, I turned around and handed it to Devon Parson, and that's it. So how is the jury going to say it would have been assault? We're firmly convinced it would have been a different instruction on assault.
What's a jury question? What's your response to Mr. Hodgkinson's argument about that? He said, I think he's arguing that the essence of that jury question would indicate that they were having difficulties understanding the subtleties here.
My response to that is, at least, how many jurors does it take to ask a jury question? I mean, I think if one person has a question, we're going to ask it. But the question dealt with what is the state's definition of authority to enter the home and aggravated assault, not with a weapon. The prosecutor said, I think we just have to refer them back to the instruction and what their definition is. And for the ag assault, there wasn't any lesser included asked for or given, so just refer them back to the instructions. This is at page 40 in volume 17. Defense counsel said, just refer them to the instructions. So there's the time to ask for it. And we're not asking for that instruction. The jury does come back. They refer to the instructions. They come back with an acquittal on the aggravated assault of Elizabeth count. So I think, maybe that was their question concerning the Elizabeth count, because she was kind of hesitant as far as whether the gun was actually pointed at her or to her boyfriend who was standing.
But she was supposed to be standing in front of him, her boyfriend.
Correct. She was in front of her boyfriend, and her boyfriend was the debtor who the defendant was trying to collect the $200.
Do you agree with me, Mr. Oberon? It's not, there's no procedural bar for a trial judge to give a lesser included instruction in response to a question.
We did not, I have not briefed that.
One is asked, because there's no verdict.
Right.
They're still there, all the jury's there. I think there's no procedural bar to doing that if the court wanted to.
There may not be. I didn't research it. I'm aware of a case where there was a jury question or the jury's deliberating and the Supreme Court of Kansas said the trial court erred in not reopening the case to present defense evidence and remanded for a hearing on that. So, I mean, I guess anything goes after the jury's instructed. If you meet the standard of whether it's a lesser or not. Yeah, I'm sorry.
assuming.
Okay. So not having researched it, probably could have done that.
Okay.
That's my response to the second issue, that's given the defense that, you know, I didn't point the gun, the jury would not have reached a different verdict. The other thing I wanted to point out was the defendant was initially charged with 3 counts of aggravated assault, or 4 counts. Tyler, Tyson, Elizabeth, and Larry, who was the grandfather. And apparently the count involving Larry did not go to the verdict, so to the jury. So the defendant was convicted of 2 counts of aggravated assault and acquitted of the 3rd count of aggravated assault. With regard to, I just wanted to quickly touch on the closing arguments. The fact that there was an acquittal says that the jury didn't take the prosecutor's comments as gospel. And that's why it's prosecutorial error, formerly misconduct, to say that, because, well, the state said it, you know, I'm with the government, so trust me. And the jury didn't do that. They were told that they're the arbiters of credibility, and they decided the credibility in that case. I don't know, my time is judged, but as to a different judge taking the verdict, I don't think that statute even applies, because the judge was not.
We have at least 3 minutes.
Okay,
so,
thank you. The judge was not disabled, sick, or deceased, or whatever the 3 standards are in the statute. The judge had another commitment that ran over and could not be there to take the verdict. And there's cases on that where you have a different judge just accepting the verdict. That's not reversible error. In fact, the judge who did accept the verdict had basically appeared on every court hearing on Mr. Sweet's case, except for the jury trial. He did the pre-trial, he did the first appearance, the second appearance, the arraignment, the prelim setting, the prelim for the co-defendant setting. He was familiar with the case. And I think this court should follow its precedent that if it is an error, it's in harmless error land, and it's not a structural error. And there's nothing in that statute in chapter 43 that says failure to follow this results in reversal in a new trial.
So what's your response to your friend on the other side's reliance on the Dixon case? And in the language in the Dixon case that talks about how the announcement of the decision is the focal point of the entire criminal trial. It's not a ministerial act. And I recognize in the Dixon case, they raised a different issue. The issue is the constitutional right to a public trial, but we still have that language about the importance of accepting a verdict, and maybe got lucky here because a lot of things can happen.
Right.
While you're taking a verdict, there could be an issue there with that. Somebody could ask to poll the jury. I mean, it isn't something that it just happens in there, and there's no, potential issues that could arise.
Right. As I recall, Dixon, the jury is set, the courtroom is emptied because there's a co-defendant trial going on, and that violates, that's a structural error, as I recall the Dixon court said. And this
That violated constitutional right to a public trial. But in reaching that, they discuss how important it is and how, announcement of the verdict is the focal point, and, a variety of things can happen. And I'm just asking you, what's your response to that point that's made in Dixon, which Mr. Hodgkinson relies on in his brief?
Bonds as a case, it's in the blue brief. I think it's State versus Chenoweth, which talks about the procedure in accepting a verdict. And if the defendant wants to object to that procedure, as far as how the verdict's accepted and the polling of the jury, they need to do it in the district court and not wait until later. And plus you have the other cases, both published and unpublished, that have said that this is merely a ministerial act, the judge reading the verdict. I mean, we're going to have a new trial because, oh, different judge read the verdict. How is the defendant prejudiced by that? How are his due process rights denied on who the judge is reading the jury's verdict? And both sides waived the polling of the jury, by the way. Unless the court has any other questions, I would rely on the blue brief as far as the balance of the arguments and ask this court to affirm the defendant's convictions.
Do we still have blue briefs? I mean, I know what a blue brief is.
I still put them out, so they're blue.
I understand.
I'll say brief about Ballinger. How's
There you
that? All right, thank you.
Thank you.
Mr. Hodgkins?
Thank you, Your Honor. Just 2 points. One, with regard to my colleague's point about, procedural default if I proceed to trial on a defective complaint. Again, we're not arguing a defective complaint. And in fact, I would assert that it really runs the other way. The state went to trial on the complaint that they wrote. And all we're asking you to do is to bind them to the complaint that they wrote. It's a curious proposition that it should be the defendant's responsibility to correct the state's charging document. The second point is my colleague asked, how many jurors does it take to ask a question? 1. How many jurors does it take to get a lesser included offense? 1, because I just need 1 juror to have a reasonable doubt. And that can cause them to not be unanimous on the greater verdict, come to a lesser verdict, or acquit on the aggravated burglary. It only takes 1. Thank you, Your Honor.
Thank you. Appreciate both of your arguments. And we take this case under advisement. Our next case is 126090, the state of Kansas appellant versus Charles Richard Ballinger, appellee. Hearing for appellant.
For the people of the state of Kansas, Ethan Zipsigler.
Appellee Tricia Bath.
What was your name, sir?
Zipsigler.
All right, your name on the brief?
Brief.
Oh, I'm appearing for the Oskaloosa attorneys. The Attorney General's office, I believe, is.
How do you spell your last name?
It is ZIPF
ZIPF.
dash SIGLER.
Diff Ziegler?
Yes.
And we have to,
You have a bar number?
Oh, yes, 24220.
4.
220.
have you entered your appearance?
I thought we have never.
You need to enter an appearance. File one, would you please? Because we have to keep track of who appears in our cases, and especially if you're going to be arguing.
Yep. Yes.
This case is set for 20 minutes. Do you want any rebuttal time?
The state would have to reserve 5 minutes for rebuttal.
Are you ready to proceed with your argument?
Yes, sir.
May it please the court. The central issue in this appeal is a question of whether the 1998 supplement to 213106 tolls the statute of limitations or extends the statute of limitations. And that is the central crux of the issue here. The state's position is that the statute extends the statute of limitations to the time the victim is 28 if certain conditions are met. And those conditions are outlined in subsection F and are, if the victim was a child under the age of 15 at the time the crime occurred, the victim was of such an age or intelligence that the victim was unable to determine the acts constituted a crime. And those are the factors that were present here and found to be present here. And the question is, under subsection 4, it says, in no event may the prosecution be commenced as provided in this section later than the date the victim turns 28 years of age. And the question is that 28 years of age a limit under the tolling, or is that an extension of the time? It is.
What's the distinction?
The distinction is if the statute tolls, then once those factors are cured, the statute of limitations begins again, and it was 5 years at the time. If it's extended to the time they're 28, then even if those factors are resolved at a later time, for instance, the person realizes that it's a crime, it doesn't then start the timeline from 5 years from that date. It extends it to the time that the child was, or that the victim was 28 years old.
So you're arguing that that 28 extends it. So you can have until that victim is 28 years old to commence prosecution, no matter when they discover it's a crime.
Yes, Your Honor. That's the state's position.
As long as two of the factors are met.
Yes, Your Honor.
Now here you've got two victims that were both under 15.
Correct.
When the acts were committed,
Yes, Your Honor.
correct? One was 3 years old and one was 10 or 11
Yes, Your Honor.
when those girls were assaulted. Is that right?
Yes, Your Honor.
And so and the district court ruled that the prosecution was time barred because what?
The district court ruled that the prosecution was time barred because in the case of MH, during the evidentiary hearing, she said she first realized it was a crime when she was in trauma therapy at the age of 17. So the district court said, well, 17, the statute starts running again. They had 5 years to bring the prosecution. The prosecution was commenced after that 5 years. And so time has been barred. In the other victim's case, it's actually much more ambiguous what the district court found. The victim had said, I first realized when I was 27 that this was a crime, and I reported it. The district court said, I don't believe that you only found out when you were 27, but then made no inquiry or decision about when the time actually started running. It was just, I don't believe you were 27, therefore time has elapsed. It's not really clear when the district court would have started the timer in that case. It was just to say, I don't believe that that was the starting time. And I think that's actually why we get to the point of the statutory construction clearly suggests that, or clearly shows that this was an extension and not a tolling, because there's almost no practical way, if it is just a tolling, to even determine when the time would toll when those factors are present.
Why have that in there? If from your interpretation of the statute, why even bother with all of that? If you say the outside limits is 28, the state has an opportunity to prosecute these people until the victim's 28. That's it. Why should there be all of these subsections in if that's the way you want to interpret the statute?
Well, because I think they still wanted to limit when you could extend it to the age of 28, and they set the statutory factors on when that new time limit.
Oh, there's still a limit of 5 years, but your subtlety of your argument escapes me, counsel.
So the limit is 5 years unless one of the 3 statutory factors on subsection F is present.
You got to have 2, don't you?
You have to have 2 of the 3. So they say that there are 3 statutory, or am I getting? Sorry, there's
They claim
4,
2,
sorry,
right.
4.
They claim 2 of the 4.
Yeah, you have to claim 2 of the 4 statutory factors in subsection F. So we claim 2. We claim that they were under the age of 15 at the time and that they were of such a characteristic that they couldn't understand what happened to them was a crime. So our position is because 2 of those 4 factors apply, the new statute of limitations is when they were 28.
Why would the statute require you finding 2 if the outside limit's 28 and you just prosecute anytime till they're 28?
Well, I mean, that's just what the statute flatly says, that it's either 5 years or if those factors are present, it is extended up to the time someone is 28 or the victim is 28.
So it never tolls until they're 28.
No, the other way, it's not, our interpretation of F is that it's not tolling, it's extending. It would toll if those factors were dynamic, meaning that at the point at which you'd resolved one of those two factors, the 5-year limitation would jump back in. That's what tolling would be. And that's how the district court interpreted it.
The statute doesn't say that, does it? I mean, what does the statute say?
Well, the statute says it is whether or not the factors that toll the statute of limitations, so those are subsection 8 is the tolling statute, and it's A through E are the other factors that can toll a prosecution, and that's any prosecution. Subsection F is for child sex cases, and it is specific to 4 factors that can be present that will extend the time until the child is 28. Or the victim.
Before these amendments, what was the law?
It was initially a 2-year statute of limitations, and then it was extended to a 5-year statute of limitations. And that's actually really critical to understanding F. Originally, it was just a tolling statute, and it was just if the defendant had tried to conceal the crime, it could be tolled during the duration that it was concealed. But what happened is the Supreme Court essentially came out with a case that said threatening the victim in a child sex case wasn't an attempt at concealment, because that's just the nature of sex cases. So we don't find that that tolls. So this statute was actually enacted in response to what the Supreme Court had ruled and changed the specific factors for child sex cases.
What case were you referring to?
That is the case of Bentley, which was in 1986. So following
More recent cases than that.
right, but my point is that Bentley had, because of Bentley, the statute was changed. And so when we're trying to say, what does this statute mean? It's clearly a response to Bentley. The legislature is saying, we don't like what the Supreme Court did, so we are going to write this statute. And the question, and it's clear that they want the time extended as long as possible to make sure victims have justice. And the reason, basically the contention between the prosecution and the defense in this case is whether or not that statute of limitations can be restarted prior to the time someone turns 28. And I don't think there's any sensible world in which it does. And we get into why when we look at the fact that there's never going to be a hard reset in a sex case of when the child had a determination of, yes, I knew this was a crime. There's no hard date. The whole point of the statute of limitations is that there is a hard date when the state alleges the last incident in which a crime occurred, and we have a certain period of time afterwards to charge that. The whole point of a child sex case is that we're never going to know when the victim gets over the knowledge of what happened to them as a crime. They may find out, they may have suspicions because of something someone said. They're in a class, someone tells them about child sex assault. They're like, well, wait, that happened to me.
Isn't this just an expression, though, of the policy that the legislature has adopted, that the state's going to have to prove something to explain why there's been such delay in the prosecution?
Yes.
So the burden's going to be on the state to present evidence that this victim sometime realized that this was a crime.
Well, I think it would
Correct?
be the opposite. The state would be presenting evidence that the victim didn't realize it was a crime. And then, I mean, again, this gets into the whole situation of there is never going, in most cases, there's never going to be evidence of when the person found out that it was a crime.
Well, there was evidence here in the first case you mentioned when she went to the psychotherapist when she got pregnant and said, yeah, I realized it was a crime when I was 17. Before that, I thought this was how normal families acted. Isn't that, or words to that effect? Isn't that what the evidence was?
There was evidence of that, but I would also suggest that doesn't necessarily give us a firm date on when she realized it was a crime, just when she realized something went wrong and then has to discern that. And the district court never attempts to create a date. You know, a statute of limitations has a firm date, but the district court never attempts to say when in 2017. What was the date? Was it March 3rd, 2017? Was it
Well, we
June?
know when she turned 17,
Sure, but
and we know 5 years on top of 17. And your complaint was filed well after that period had expired, correct?
yes, Your Honor, but my point is more that works here, but by the very nature of the fact that we have to be so vague in this case, that supports the interpretation of the statute that it was actually meant to be an extension to the time that someone was 28 and not just a tolling of this 5 years until those factors are resolved. So
I'm more interested now in your second issue, and that's the application. I understand you disagree with the interpretation of the district court
Yep.
in this particular instance. But your second issue intrigues me, and that's the application, especially to the second case where the victim said she realized when she was 27. Is that right?
yes, Your Honor.
When she was 27, she realized it was a crime. Now, this occurred when she was 3 years old. I
thought that I think that may have been the victim who was older at the time, though I may be mixing them up.
Well, anyway,
The Casey is the one who testified that she realized it when she was 27. It happened at 3, but there's also testimony that she'd repeatedly brought it up to her mother and was upset that her mom married Mr. Ballinger after she had told her about the incident.
so that's the case that I'm referring to, that count. What's your position on what the court did in ruling on that?
In the brief, they argue that I don't think they applied the correct legal interpretation, that the court had to apply the evidence in the light most favorable to the state. I think it's still just, would there be substantial competent evidence to support a finding that the victim didn't know about it beforehand? My interpretation here of what the actual problem is that the district court flatly says, I don't believe it took you until you were 27 to find this out, but then doesn't allow an opportunity or any sort of investigation into, okay, then when does the time toll? Like, when did they actually know it was a crime? Not that there was something wrong, not that something happened, but that there was an actual crime to report. And there was never attempt to do that. So we're left with the only evidence on the record is the preliminary hearing transcript. So we're in this weird situation of there was just a flat denial. Like, I don't find this one date credible, but there's no attempt to say, okay, well then when are we going to apply it? And that's my issue, is that there's nothing to support the district court just flatly throwing out that she didn't know it was a crime until later in her life. It's just, I don't believe you were 27, therefore what? And I think that's the problem. There's no evidence to support what the district court did.
Did the state have a burden at this hearing to prove anything?
Yes, the state had the burden of proving one of the statutory factors existed to toll the statute.
And the substantial evidence that the state presented was what?
I believe is the preliminary hearing
At
transcript.
the preliminary hearing?
Yes.
Okay. That's what was used. There wasn't any testimony
Yeah,
taken.
that's my understanding.
If the district court found that the statute of limitations had run well before Casey turned 27, based on her testimony that she'd repeatedly complained to her mom, even before her mom married Mr. Ballinger, does it really matter if the court picks a date, because they're all ancient history by that point?
So it matters if it's tolled, if the statute's tolling, but it doesn't matter if it's extending. If it's extending, then the only factor that matters is whether at the time of the crime she could form knowledge that it was. If it tolls, then yes, it absolutely matters the date, because we have to know a specific date so that we can find when the statute ends. And again, this kind of goes back to my point of the two things feed together. You're never going to have a solid date in a sex case involving a child who didn't know it was a crime of when they fully comprehend that it is. a child is going to go through stages of knowing something's wrong, hearing other people say something's wrong. Maybe they disclose to a friend and the friend says that's a crime and they don't believe them at first. So I don't think it could be possible that this statute was meant to read as a tolling statute, because that just factually will never happen. And then
That you have a 5-year statute of limitations help with some of the squishiness of figuring out when it starts and stops.
not really, not to me. It doesn't.
Still quite a bit of time.
It is, but again, in sex cases are unique, and that's sort of the whole purpose of why the legislation kept changing, is that they present unique challenges. And I think the fact that the statute was initially changed in response to the unique challenges that are presented shows that it was intended to extend. And it also, like, the base.
Back to your point on the extension, I mean, to be honest with you, I'm struggling with your interpretation, given the language of the statute, which talks about the period within which a prosecution must be commenced shall not include any period in which, and when we jump down to F, it talks about two or more of the following factors are present. So that's my first problem, is we're talking about, as long as these are present, we've got, the way I read it, the statute being told. And then we jump down to the end where they talk about the victim being 28 years of age. If it's an extending, if it's an extension statute, then why do we use language to say, but in no event may a prosecution be commenced as provided in this section later than the date the victim turns 28? That seems to me a hard stop,
And
not an extension. Up to 28, it's saying, okay, while these factors are present, we can toll the statute, but we're not going to toll it beyond 28. Not, we're going to extend the statute of limitations until they're 28.
I think there's a couple of things. One, I think the language that you're talking about in 1 and 2, the fact that it was under the age of 15 and was first of all, I would say that if we are talking about this as mere tolling, then it kind of renders, then the age has to be 23. I mean, almost certainly, because the victim was under the age of 15 is going to, at some point, the victim's going to be 16, and that factor goes away, if that's a dynamic factor.
Well, this talks about the victim was under 15 at the time of the crime.
Okay,
That's the only factor that mentions at the time of the crime. So we've got that here, there's no question. And now we're just determining whether or not she was of such an age or intelligence that she was unable to determine that the acts constituted a crime.
Right. And I think, again, you're there.
The statute says as long as that factor, the 2 or more of the following factors are present, then you can't commence prosecution. So
And-
that tells me as long as they are present, you can't, but once they're no longer present, then you can commence your prosecution.
Well, and then I would still say that 2 is the language of was. It is the victim was that. And so the victim is wasn't of those qualities, that they couldn't discern that it was a crime.
Well, here
At
she was, I mean, right, don't we have evidence that she wasn't unable to determine the acts constituted a crime because the court found she testified she became able to determine the acts were a crime by complaining to her mom, by talking about the fact that she realized these things were wrong in therapy.
Right.
So then that's when the court said, okay, that factor went away. It was no longer present
And-
based on that evidence.
And I think the problem is that again, I think the way the statute is written, that timing is reflexive to why the disclosure never happened, not to an ongoing system of trying to figure out when the child figured it out. And again, I go back to, it's impractical because in most cases, we're never going to get a date. So how would we ever apply that correctly? Because there's no point in time at which the victim is going to know, well, it was March 23rd of 2027 when I first found out, or 2017 when I first found out this is a crime. They're going to have moments where they start to realize things are wrong. And so creating a firm date is almost impossible. So to me, that reads as that is reflexive to at the time it was not disclosed, not an ongoing thing that is measured.
But aren't you reading that factor to be the victim knew, as opposed to here we have the victim was unable to determine?
I'm I might not understand the question. I'm sorry.
No, and it was probably inartfully drafted, but your argument seemed to be directed towards the fact that we're never going to know when the victim finally knew that it was a crime. So because of that, we can't read this as a dynamic factor. But my point is the statute talks about how the victim was unable to determine that the acts constituted a crime. So we don't require the precision that you're arguing. We don't require proof that the victim actually knew. We require proof that there was evidence that they were unable to determine that the acts constituted a crime.
And I guess, Your Honor, my response would still be that it is still so impossible to determine, to know when they could determine it, because it's which date are you going to use? Is it the first time someone said something was wrong, or they felt like something was wrong? Or is there a specific moment where we can determine that, or we can find factually that they could determine it? I think because that's never going to be the case, that's never going to be provable, it has to be the interpretation that this is an extension. Okay, that's all. Sorry. Yeah.
I would just, is he on his time?
I allowed him to go over,
Okay.
Judge Hill, because this is an important issue.
Oh, I don't have anything else, Your Honor. I was.
Okay, okay, before you, what's your first name?
It's Ethan, Ethan.
Thank you. Ms. Bath? I allow the state to go over and, let me see here. They went over about 7 minutes. You can have 27 minutes if you want.
Thank you. I'll start by admitting to your honors that I feel a little ambushed by the state's argument this morning. And by that, obviously, your honors have reviewed the brief based on your questions. But Mr. Zip-Sigler began by telling this court that the crux of this argument is whether the section 2I tolls or extends the statute of limitations, and it extends it to age 28. I'd invite the court to review the state's brief at page 4, where they say the crux of this appeal is the interpretation and application of 2I, which is KSA 21-31-068F 2I. The victim was of such an age or intelligence as the victim was unable to determine that the acts constituted a crime. And for the bulk of their brief, what the state argues, and I understand Mr. Zip-Sigler was not on the brief, but what they state argues is not what Mr. Zip-Sigler argued here today. They do include this 28-year-old provision, and frankly, it's in reading the brief, I think a little hard to tell what exactly they were trying to argue with regard to that, and I'll get to that because I think the statute is actually quite clear about it. But what they argue in their brief is whether the legislature intended 2I to be static or dynamic. This is the word they use throughout their brief. And that's what Appali was prepared to respond to today, is that the brief that we've had in our hands for months.
Well, let's hear your argument on that.
Okay.
Now that you're a good advocate, let's hear your argument then.
Sure.
What's your best argument about whether this is, first of all, define your terms. What do you mean by static or dynamic?
Well, those are some
I'm
terms
curious.
that the state adopted and used throughout their brief. And what I believe they're trying to say to us, Judge, is that for example, 1I, the victim was under 15 years old at the time of the crime. The state argues clearly the legislature intended that to be static. And I agree, that won't change. The victim's age at the time of the crime will never change. I mean, it may have happened. She may have been 12 and 13 and 14 and 15, but her age at the time of the crime is static. It's set in stone at the time of the crime. And this legislature indicated to all of us that they intended that to be static when they added the words at the time of the crime to only that subsection.
So that is what I would call a statement of policy.
Yes. When we look at the next subsection, and that's the one that inquires whether the victim was not able to, I don't want to misquote the statute,
Unable to determine the acts constituted a crime.
age or intelligence that the victim was unable to determine that the acts constituted the crime. and even look at the other two statutes, because as we indicate in our brief, we can determine whether or not a statute is plain and ambiguous in part by this doctrine in peri materia, where we say we look at the whole statute to determine whether it's clear to begin with. And so if we look at little 3I, the victim was prevented by a parent or legal authority from making known to law enforcement the fact of the crime. And little 4, there is substantial competent evidence, paraphrasing, that the victim psychologically repressed the memories of the incident.
But there's a caveat there, isn't there? In that particular section 4, you have to have some quality of evidence, don't you?
We do, and I don't want to get too much off track because I'm going to talk about that as to this 28 years old issue there. The quality of evidence on repressed memory is there has to be corroborating evidence, and frankly, it would be tedious to read all of subsection little Roman numeral 4 into the record, but we'll head down that path, I guess.
Well, there has to be competent psychological proof of that.
Right,
correct?
there has to be substantial corroborating evidence, and in that same sentence is where the language, but in no event may a prosecution be commenced as provided in this section later than the date the victim turns 28 years of age, period. And then it says corroborating evidence may include. Clearly, the sentence that follows the 28-year-old provision is still referring to the corroborating evidence that's necessary to prove psychologically repressed memory. So the 28-year-old provision is part of subsection little Roman numeral 4. It does not apply to the entire subsection 8F as the state would indicate.
That's what I wanted to hear. If your argument was that 28-year provision applied only to that particular subsection.
Absolutely. And that was the state's argument at the district court level. They said it clearly applies only in cases where the state is operating under little Roman numeral I4 or little 4 IV. And the state made a little bit different argument in their brief and another little bit different argument here with the court today. But I think any argument that this subsection, all of 8F, is an extension to age 28. One, I agree with Judge Klein that it reads like it's a hard stop. It doesn't say all of these get to be prosecuted until you're 28. The legislature knows how to do that. They've amended the statute at one point to say statute of limitations starts when you're 18. They've amended it to say there is no statute of limitations for adults or children. So they understand how to extend or do away with statute of limitations. The language about being 28 years old is, I think, very intentionally not just included in little Roman numeral 4, but there's no stop in the sentence. I'm not even sure there's a comma from where it says there is substantially competent expert testimony indicating the victim psychologically repressed. And then we talk about what evidence there may be, but in no event may a prosecution be commenced as provided in this section later than the date the victim turns 18 years of age. Corroborating evidence may include. I don't know that the language could be more plain there. To the extent that anybody ever thought it was, if you look at the very last page of the state's brief, it's not their actual written brief, it is attachment B. They include a little attachment regarding legislative history, and they say that the legislature told us in 2012, they clarified that the 28-year-old provision applied only to the subsection in which it appeared. State wants to say, well, that means subsection 8, or that means subsection 8F. Well, it appears in subsection 8F, little Roman numeral 4. And that would be our provision, is that argument that there's some 28-year-old extension has no place in this case regarding these facts, because we don't have a repressed memory situation. The victim said some things to the trial court that she had suppressed her memory, that she tried really hard not to think about it because it was disgusting, but that from time to time it crept back into her mind. She also told the detective that she'd been thinking about it for a really long time. But certainly there's no evidence from an expert or anything along those lines. We're not dealing with Roman numeral 4, and I would submit to you, we're not dealing with anything to do with anybody being 28 years old in this case. And the state's argument is just flat wrong. So with regard to the argument they make in their brief, unless they're abandoning that argument today, in which case I guess we'll take it. The argument they make in their brief is that subsection little 2I, which was the only other issue before the trial court, is also intended to be static. And they want this court to read language into the statute that at the time of the crime, the child was of such an age and intelligence such that the child did not understand the criminal nature of this act. That's not there. We all know that there's plenty of case law out there that tells us that the legislature is presumed to know the state of the law. And in fact, these provisions were all written at the same time. It was a singular amendment to add 8F. And as Mr. Ziegler indicated, it was in response to a Supreme Court case, the Bentley case, where the court had found no concealment. And I think oftentimes it's very clear when the legislature is writing in response to a Supreme Court case, because where 8F starts is whether or not there was concealment. And then they go on to say, these are the things that are going to toll the statute of limitations. They were making it clear that they did not believe concealment had to be present if these other factors, two of them, were present. So the Supreme Court or the legislature wrote these 4 provisions of the statute, Roman numerals little 1 through little 4, at the same time, and only in number 1 did they include the language at the time of the crime. The state encourages you in its brief at page 12 to sort of read around the time of the crime into little Roman numeral 2. At page 22, they say, let's add at the time of the crime. And we, in our brief, of course, argue that the plain language, including using, if necessary, the in para materia doctrine to find out whether the language is in fact plain, tells us that the absence of at the time of the crime in little 2I was intentional.
Did the accused have the burden to prove any of this?
No, he did not. The statute clearly puts a substantial compelling evidence burden on the state. The accused has a duty to raise it because, of course,
It's an affirmative defense and you have a duty to raise the affirmative defense.
Right. And then the state has the burden to prove that tolling applies.
What evidence did the court rely upon?
Well, the state not only didn't present any evidence, they inserted some sort of chart that's never been a part of this record. And we were not counsel at the trial court level. They not only didn't present evidence, they didn't file a response to the motion to dismiss for statute of limitations.
Was there any transcript of the preliminary hearing available to the judge?
The defense counsel asked the court to take judicial notice of the preliminary hearing transcript, and the court did so. I suppose if the state wasn't calling any witnesses at the hearing, maybe that was a mistake by him to put on some evidence for them. But defense counsel had been at the preliminary hearing where the court, even at that time, expressed some concerns with the testimony that the second alleged victim, case C, was giving. The defense counsel asked a preliminary hearing for the court to not bind over on the charge related to her because of the sometimes erratic nature of things she was saying. And those are detailed in our brief, and I can certainly go over some of those if we'd like to. But the court made reference, again, paraphrasing, he said something along the lines like, okay, well, you're talking about the dreams and the delusional stuff. I have to view the evidence in the light most favorable to the prosecution at a preliminary hearing. And so he bound over, but he clearly made reference to the fact that he had some issues with the things that this alleged victim had said. And at the time of that hearing, in fact, at the very outset of the hearing, counsel for the state advised the court, we may have a statute of limitations motion that the defense is going to file down the road. So the state knew a statute of limitations motion was coming. They too heard the kind of crazy things that this alleged victim said at the preliminary hearing. They heard what the judge thought about them, and they didn't call her back at a hearing on the motion to dismiss.
Was it the same judge?
It's Judge Etzel.
So he was the same judge for the preliminary hearing
Yes,
and heard the motion,
yes.
the statute of limitations motion. Is this there was an argument, if I recall correctly, in the briefs that this should be submitted to the jury. Let the jury decide about when this lady had these memories and when she became aware.
His brief did include a statement that, that statute of limitations is quote unquote generally a question for the jury. And they cited the Palmer case, and that's not what the Palmer case says. In fact, the Palmer case, there was a discussion of the lower court having dismissed 2 or 3 counts of theft, and the court upheld that dismissal on statute of limitations grounds. They said under these facts, one other issue was a question for the jury, and it was a complicated campaign finance contributions count. The defendant was head of several different companies, and lots of different people were making campaign contributions to all these different companies. And so the question for the court was whether that was active concealment. And essentially it was like, well, there's so much going on here. We can't have a mini trial. Was it concealment if a reporter, which is who sort of broke the news, was able to determine that something fishy was going on here? Was it really concealment, or were these people just giving their money to these various companies, or were they all trying to hide that they were illegal campaign contributions? And so the court said, under these facts, whether or not there was concealment, and therefore the statute of limitations issue.
So it was
was
a
a jury
question of
question.
whether it was concealment, not whether the date of the act.
Correct.
So getting back to my question, is this a jury question?
I don't believe it is, Judge, and I think I understand this is not an immunity question, but I would point to the court, and this is not something I brief, but something I know because it's a case that we had. I would point the courts to State of Kansas versus Dustin Evans and State of Kansas versus Hardy, Hardy. They were decided the same day. They were both cases of first impression on stand your ground immunity. We lost Evans here at the Court of Appeals. None of your honors were on our panel, and Hardy also lost. None of your honors were on that panel at the Court of Appeals. And they both went up, and Justice Stiegel wrote the opinion that date. And there the discussion was about essentially if the idea of the stand your ground immunity law is to kind of stop the prosecution before it even starts, before a defendant even has to go through all of that, then it needs to happen as early as possible. And that's what I would say with regard to this statute of limitations defense. If the state can't bring the charges, a defendant should not be required to go all the way through a jury trial just to hear the jury say that. Moreover, it can sometimes be a tricky question of law. Obviously, we're all here arguing about what we think the statute means, and I don't think statutory interpretation or legal issues like this are appropriate questions for the jury. As to, I guess the application, I know Your Honor had a question for Mr. Ziegler about that. As to the application, quickly as to the first alleged victim, MH, I think if the statute is interpreted the way that we urge in our brief, which is that it means at some point the victim was unable to discern the criminal nature of the crime, not at the time of the crime, and that when that stops, the statute resumes running again, statute of limitation resumes running again, and that the state is required to prove substantial competent evidence as to when that was. The judge doesn't have a duty to pick a date. And I think that Mr. Ziegler said something about there was no opportunity given by the judge and no investigation by the judge as to what the date was. That's not the judge's job. The statute very clearly puts the burden on the state. But as to MH, there really is not a factual dispute. She said, I was 11 when this happened. So they charged the very last date would be her birthday, her 12th birthday, March of 1999. I learned it was a crime in 2004. So the court says, yes, there was substantial compelling evidence that the statute of limitations was told until 2004. Thereafter, it began to run. It ran for 5 years. It expired in 2009. There had not been any amendments to change it. We can't revive a dead shot statute of limitations, and so that counts goes away. With regard to the second,
And this prosecution was commenced in what?
22.
Filed in 22.
As to the second alleged victim, the court said little 2I is a harder factor. He did not say, just keep saying, I don't believe her. I invite the court to read his order. I think that's in the record, it's record 5, pages, I think 15 through 19. But what the court said is ultimately held there's not substantial compelling evidence that she didn't realize it was a crime until she was 27. So the court can't say, well, I find there was substantial compelling evidence that she began to know it was a crime at this date or whatever. He did essentially say totality of circumstances, which the state apparently concedes today is the right standard of review. Heretofore, their brief had said it's the light most favorable to the state. And that's why I was even looking at our Hardy and Evans cases, because that issue was taken up there and said, just because you might be using evidence from a preliminary hearing doesn't mean we use a preliminary hearing standard. And those are even a probable cause standard, and this is obviously different. But what the court said is the state has this burden to provide substantial compelling evidence as to when this is told. And they didn't. The court doesn't have to fill in the gaps for them. Again, this alleged victim was sort of all over the place, not only as the things that Judge Klein has already mentioned, that she remembered in a meditation when she was 27, that she knew about it and told her mom about it repeatedly until she was 5. And then she stopped thinking about it for a while between ages 5 and 27, but she always knew about it. She didn't forget it. She just tried to suppress it because she thought it was gross. She remembers being mad at their wedding when she was 3.5 years old because mom was choosing to marry him despite what he had done to her. She made claims of having memories from back, unrelated to this, but memories back from when she was 2 years old. But she also went into having had premonitions when she was 5 about a murder that happened in the town of McLouth that is now the subject of a novel. So when she got this information, whether it was at age 5 or from reading the novel, I don't know. She told a story about how a Dalmatian dog came to her door and its skull had been very precisely removed to expose its brain, and that she believed the defendant, my client, had done that because he had tools and he knew how to use tools in his shop. So I sort of, I guess say to the state, like, how much, when we start getting into some, she heard voices, she talked to her future self. When we start getting into a witness who is saying things like that, how much of that is the judge supposed to say, well, I'm going to throw away all this stuff that seems a little not based in reality, but I'm going to credit her testimony that she learned this was a crime when she was 27. If she had said the Dalmatian dog's the one who told her this was a crime when she was 27, does the judge have to believe that? In addition to that, she made statements on cross-examination that she had talked to her family about it. They didn't want to report it. She had researched specifically statutes of limitations. She didn't say those words, but she said times and time frames of when this could be charged. She indicated one of her last questions, and it's in our brief. I don't want to misquote it, but it's directly quoted in the brief. The question was, you didn't wait till you were 27 to tell this to police because that's when you first realized it was a crime, right? And she said, as soon as I remember it was a crime, or some answer that was a non-answer. And there were a lot of those things. The question was asked and she couldn't provide an answer. And the judge sort of referenced a lot of that, not all of that, but certainly he had the opportunity to review the preliminary hearing transcript. He referenced all of that in his holding that the state simply had failed to establish substantial and compelling evidence as to tolling regarding that little 2I factor.
In terms of little 2I, do you think the court is supposed to view that factor with a subjective or an objective standard?
I think the only way you can do it is subjective. And there's going to be testimony, and I know Mr. Ziegler argued you'd never be able to prove this. Well, we have cases where it's been proven. MH, the victim in this case, said, I understood it was a crime when I was 17. And the court took that at face value. I don't know that the defense would ever really be able to prove she didn't understand it was a crime. A lot of times you're going to have corroborating factors like I understood it was a crime when I was 17 and I told the police. And so you're going to have contemporaneous charging. There is a case that's not cited by either of us because there wasn't a lot of statutory interpretation. It's an unpublished case from this court. It was Judge, now Justice Standridge, Judge Boozer, and Judge Bruns. I think I've got it in here. No, Judge Standridge, Bruns, and Gardner. Weeks, State of Kansas versus Weeks, 425 P3rd 1273. It's a 2018 case. They were looking at statute of limitations. And that little girl said this happened when she was 6 or 7. When she was 9 or 10, she went to a friend's mom and she began to understand that this was a crime. She told the mom, who told her mom, and then they made a police report. So the notion that we're never going to be able to figure this out is belied by those cases. But to your question, I think we're not going to have objective proof of when they absolutely knew, or this should have known standards at the tail end of the state's proof talks about. The state's just going to have to present that evidence. And if the court finds it credible, then the court can find that the statute of limitations was told as to whatever that date was. In this case, the court simply didn't find that the state had presented credible or competent evidence of any date. If he didn't believe the 27-year-old date, he didn't have to come back and find another date. That was the state's job, and they didn't do it. And I think the dismissal was proper. Last thing I do is remind this court, I know I probably don't need to, but we've got the rule of lenity when we're dealing with statutory interpretation and defendant. Sort of tie goes to the runner for the defense. We've got rules that statute of limitations are favored in the law. I understand there's been a subsequent amendment to say, well, as to rape, we're not going to have one. So maybe it's not favored as to rape anymore. But, and we've got the law from Palmer that says exceptions to the statute of limitation are narrowly construed against the state. I think all of those things act in favor of finding that the district court was correct in its ruling and affirming that ruling. Thank you.
Mr. Ziegler, you have some rebuttal time.
I'll just make a rebuttal at this point, Your Honor.
Okay.
Unless Your Honors have a question for me.
Thank you.
Thank you.
Bridget. Our next case is 125-745, State of Kansas versus Misty Marie Lake. Appearing for the appellant. Thank you. Would you want any rebuttal time? This is 15 minutes. Okay, 3 minutes. And appearing for the state.
Good morning, may it please the court. The state appears by Jody Lippman, Deputy District.
Thank you. Mr. Hutchinson, are you ready to present your argument?
Thank you, Your Honor. My name is Randall Hutchinson. I'm appearing this morning on this case on behalf of Misty Lake. Your Honor, I just remind you that this case is about an incident happening down Huntston Street here, down 12th Street at Skinny's Bar and Grill, off of Gage. And again, certain facts aren't particularly contested in this case, that my client and her daughter, adult daughter, were at the bar. And at some point, a group of other girls came over to the bar and there was antagonizing between them. And at some point, the girls who came over to the bar said, you need to come outside. And so my client's daughter went outside with these girls. And I think there's no dispute that there was a fight outside in the parking lot. And there's at some point, one of the girls that came to the bar, Vanity, is shot and has substantial injuries regarding that. So in this, my client is charged with aggravated battery, intentional aggravated battery, or intentionally causing great bodily harm. My intent is primarily to argue about the first issue, although maybe tie it into how it might be also cumulative error. It's sort of interesting, Your Honor, as an appellate lawyer, as I step into a case like this, and I'm reading I'm reading this record, and you're reading it and going through it, and you get to the end of the facts, and you think, well, this seems like a self-defense case. And then the attorney in the case doesn't request a self-defense instruction.
Or defense of another.
Defense of another, and yeah, that's right. In this case, because you certainly see these facts where the facts are that daughter is out in the parking lot, and there's particularly viewed in a way most favorable to my client for this, that she goes out and there's a group of people out there and that there's this ongoing fight.
But counsel, isn't that why we have the 1507 procedure?
It's a separate issue. I mean, yes, there might be some issue about, like, ineffective assistance of counsel. But I'm bringing this issue to this court to say, even in a case where a defendant doesn't request an instruction, the court is still required to give adequate, accurate instructions. And so,
Well, I guess I'm just going to be upfront with you. What I struggle with is I don't see how the defense of others jury instruction is consistent with the theory of defense. And I recognize that you argue in your brief that a defendant has the prerogative to argue inconsistent defenses, but I don't see how the court gets to step in and make that decision for the defendant. Like I believe the law gives the defendant agency over how they want to present their defense, and we don't want the court coming and mucking that up.
so, Your Honor, it's our argument, and I think an accurate argument, that it's not inconsistent. So our client's defense that was presented was she didn't shoot anybody. She didn't shoot anybody.
Right, it wasn't me. I shot it up. I shot up in the air, or somebody else was shooting a gun. It wasn't me.
That I didn't shoot. But I also recognize that the record contains evidence that my client shot the victim in this case. And so, there's not a sufficiency issue in this case. And so, to the extent that a jury could find, and apparently did find in this case, that my client intentionally shot Vanity, now the question is there any legal excuse for that? That's not inconsistent. The idea is we argued we didn't do it.
How is it consistent when your client says, I didn't shoot her?
But the
To
jury
now
found that
say, actually, you did shoot her, but you had a good reason, you had a legal reason to do it.
but the jury found that she did shoot her intentionally. So now the question is, even if that's true, and we take the jury's verdict for this issue as that being the case, can there be a legal excuse under Kansas law? And the answer is yes. That a person acting in defense of another is intentionally shooting somebody. But it can be excused under the correct circumstances. So the question should be, is a defense of another instruction legally and factually appropriate? What arguments the defense makes is irrelevant to that question of whether it's legally and factually appropriate. It's irrelevant to that.
Why would it be irrelevant? I mean, we've got the defendant arguing to the jury what happened and why they're not responsible under the law, and why they should be found not guilty. I mean, that's the focus. And then you're saying we should add in these jury instructions that are completely inconsistent with that argument. The jury goes back to the jury room and they're saying, where did this instruction come from? Nobody offered this defense. What am I supposed to do with it?
Okay, there's a couple different things I think in your question, Your Honor. So first of all, we don't agree that it's inconsistent, right? And so the question should be, is it
I understand your
defensive-
point to be it's not consistent with the facts, but my point is it's inconsistent with the defendant's defense.
but
And how is it the judge prerogative to interject an argument that's inconsistent and impair the defendant's defense in that way?
right? It doesn't impair the defense. It doesn't impair the defense.
If the defense is I didn't do it,
I didn't
and then
do-
now we're interjecting an instruction that says maybe you did, but you had a good reason. I don't see
So the defense could still completely argue, we didn't do it. We didn't do it.
that's what they argue. That's all they are.
That's right.
Right.
But the jury, to the extent that the evidence in a light most favorable to the defense shows that it could have been defense of another, the jury could say, well, sorry, we disagree with your defense, defendant. We think you did intentionally shoot this person.
And that's what happened here. I mean,
That's what
they have
happened.
the verdict form to say, I believe your defense or I don't. That's how I answer the questions on the verdict form, and that's how
Yeah.
the trial should go. Instead of let's give them the whole pick book to look through and say, well, what else is in here that could match up with these facts?
It's, yeah. The judge is supposed to give complete, accurate instructions on law that the jury can use to evaluate the case in every aspect, not everything in the pick. It has to be legally and factually appropriate. Is defense of another legally appropriate? Is there such a thing as defense of another? Yes. So the question is it factually appropriate in this case?
Well, and get back to the question of legally appropriate. You don't have a suggested jury instruction, right? And isn't normally the question of whether a jury instruction is legally appropriate. We're looking at language in the jury instruction to see if it fairly and accurately states the law. And here we have no proposed jury instruction either below or on appeal. So how would I even answer the question as to whether some vague instruction on defense of others is legally appropriate if I have no language to look at?
There's a pattern instruction on defense of another, Your Honor.
But that's not what you're offering. I mean, that's not referenced at all in the brief, and there wasn't any instruction referenced below, so.
Well, it wasn't
Are we supposed
requested
to look
below.
at-
You're right. I mean, I acknowledged in my brief that it wasn't requested below. I was arguing that they should have instructed on the law of defense of another.
Right, but you didn't
may be
reference
right.
a pick instruction, you didn't say, or along the lines of the
Today, I would
statute.
suggest that a pick instruction. If I don't ask for something different, then we generally would say that the pick instruction would apply. I mean, to the extent that the question of whether it's legally appropriate is there any such thing as this under statute or our pattern instructions? The answer is yes. And then the question is it factually appropriate? And in a view and a line most favorable to my client in that situation. And that's why it's not inconsistent, because the jury could decide, oh, well, we disagree with you. We think you did do this. But then a jury could also say, but we have, or actually not the jury, one or more jurors could form a reasonable doubt and say, but we think you were doing this in defense of your daughter. And if they do that, my client should not be convicted of aggravated battery. That's why it's not inconsistent.
Isn't it up to the defendant to make that suggestion?
I think Kansas law says,
Theory of defense. I mean, I think it's the Trussell case that talks about how it's not the court's job to jump in and interject contradictory and inconsistent theories of defense, that it's up to the defendant to select how they want to defend the case.
yeah, Your Honor. I mean, and it feels like we're at a disagreement about whether they're inconsistent, because I believe it's not inconsistent to say I didn't do it, but if you find that I did do it, there was a legal excuse for it. I don't think those are inconsistent. And to the extent in my brief, I'm saying that's why Trussell is wrong.
But my point is they're inconsistent with the only defense the defendant offered.
It's not inconsistent.
But the defendant never argued, I did it and I had a good reason to do it. Did they?
No, the only argument was they
Thing
didn't do it.
We're looking at what the defendant argued and not what the facts could support. It's the defendant's prerogative, isn't it, to decide how they want to defend their case?
But there's nothing in the law as it's developed with regard to legal appropriateness that says you look at the defendant's arguments.
I thought that's what the Trussell case talks about, that we don't want to confuse the jury.
That Trussell case predates Williams and all the cases that have talked about legal and factual appropriateness.
But that's a different question.
No, it's the exact right question of whether or
Trussell
not.
deals with whether the jury instruction should even be requested. But the later cases talk about if it's requested, let's first look at the language to see if it's legally appropriate, and then let's look at the facts to see if it's factually appropriate. I mean, it seems to me they answer two different questions.
Your Honor, I respectfully would argue that the cases, Williams and these cases that have come afterwards, Plummer, argue that, no, you always decide whether it's requested or not to determine whether an instruction should be given. The question is it factually and legally appropriate? And so the legal appropriateness has nothing to do with what somebody argues, and the factual appropriate has nothing to do with what somebody argues. It relies on what the evidence was presented in the case. So if, for example, if the judge said, hey, I'm thinking about giving a defense of another issue in the instruction in this case, and the defendant said, I don't want that instruction given because I think that's going to interfere with my defense, then I think I'm in a much different place. Because that's, I think, invited error. I think even I would have a hard time arguing about that. That's not this case. This case was, there was one argument made, one defense presented, and that defense is not inconsistent with defense of another. That if the defense, if the jury finds, as it did in this case, that my client did shoot somebody, there's an additional analysis that a jury could make. And if one or more jurors said, okay, we disagree with you, defendant, about this, but I still have a reasonable doubt based on these facts that it was, you were defending your daughter, the jury would have come to a different, or one or more of those jurors would have come to a different
I
verdict.
struggle with the burden that you're placing on the district court and the manageability of that, for the district court to say, in addition to whatever instructions you're suggesting, I have to read through PIC. First of all, the jury instructions are suggested before trial, so the judge doesn't know the facts, so we wouldn't know the factual basis. So then we're only talking at the jury instruction conference after the evidence is entered. Now the district court judge, you're saying you're supposed to put the onus on the judge to say, all right, here are a couple of other defenses that I think maybe the facts would support. What do you think about this one? What do you think about this one? As opposed to the onus being on the defendant to choose how they want to defend themselves in the case. Seems to me you're placing the burden on the district court as opposed to the defendant in this situation. Am I wrong?
I am arguing that it is the district court's job to instruct the jury accurately and fully. And I don't think they can abrogate that or delegate that to the advocates. Now, certainly it is the case that it's different. That's why I'm on a clear error standard. If I'm in a different place as an appellate advocate today than if I had requested this instruction. And in fact, again, let's say I said, my theory of defense is we didn't do it. And I also request defense of another.
Which you would have the right to do as a defendant.
Which I have a right to do. Is that legally possible under the law in Kansas? I think yes. And so that's not inconsistent. So the only question that, so no, Your Honor, I think, again, it's where I started with this case. I read this trial and I think she's arguing she didn't do it, but if she did do it, there's also a lot of evidence that she was doing it to defend her daughter.
All right, let's talk about what evidence you have that would make that instruction factually appropriate. It seems to me in your brief, you're relying on a statement that the defendant made to a separate witness, not the one who was shot. Is that correct?
It's part of it, yeah.
And then a statement that she made to her daughter after the fight, giving a different explanation for why she shot the gun.
It's
Correct?
it's
Those
all
are
of
the
the
two
it's
pieces
all
of
of the
evidence?
circumstances. It's not just the statements.
What else?
It's the fact that she walks outside and sees her daughter, another person on top of her daughter hitting her daughter, and a group of people around them when they come out of this bar, and there's dozens of people out in this parking lot. But those are the circumstances that, again, could one or more jurors form a reasonable doubt that I think maybe she was acting in defense of her daughter. It seems to me that in a light most favorable to my client, and when you look at the totality of the circumstances, including the statements and including the testimony of Shaley and so forth with regard to the circumstances when Shaley got out into the parking lot, that evidence that one or more jurors would, that there's a real possibility that one or more jurors would have formed a reasonable doubt in this
Did the
case.
defense counsel raise this in closing?
Defense of another?
Correct.
No, Your Honor. Judge Klein's exactly right. I mean, the defense counsel below, the focus of that, the exclusive focus of that argument was my client didn't do this. But I don't think and I don't think Kansas law excludes then the possibility that a jury could still consider whether it was done in defense of another. That's all I'm arguing.
The question then becomes whether you can convince us that this was clear error not to do it.
That's right. And I acknowledge that in the brief, that I'm on a clear error standard.
And our reasons for overturning the decision would be what? What is there in this record that would compel us to do that?
Again, when I read this record and I get to the end of it, and I think, if my client did this, I'm not admitting that, but if my client did this, why did my client do this? And it seems clear to me, based both on the statements and the circumstances, seems clear to me, and I don't have to be clear, right? It just has to cause one or more jurors to have a reasonable doubt that maybe she was doing it to defend her daughter. And if that's the case, then there's a real possibility that one or more jurors would have acquitted had they been given that law. And that's all we're asking for, is to say, to have a trial with all of the law that I guess it just doesn't seem like that much of a burden, Judge Klein, to look at this record and think, well, if she did do it, it seems like she was probably, or at least possibly doing it to defend her daughter.
But don't we have to look at the situation, not in just this case, but you're asking us to adopt a rule for every case where it would be the judge's obligation and not the defendant to come up with all possible defenses that the facts would support and then instruct the jury based on all those defenses. I mean, whatever ruling we issue here would apply not just to your facts, but going forward.
Sure. But I don't think that's I'm not asking you to do anything new there, Your Honor. I mean, we've always had, and there are other cases where we've dealt with affirmative defenses that haven't been raised below. But then you can still have an issue of should the judge have given an instruction on that? And the question is it legally and factually appropriate? We have a different reversal standard. It's going to require more persuasion on the appellant's part in those situations, but it doesn't mean that it shouldn't be given. And I guess I'll end with, because I'm sure I'm over my time, that even if you don't, again, because even if you don't find it's clearly erroneous just on that, it is, I think, because in our second and third issues, I think we show that there are other errors in this case. And so even if you don't think it's clear error in this case to have not given defense of another, together we think that it shows that this trial is riddled with errors and should be tried again. Thank you, Your Honor.
Good morning, may it please the court. The state appears by Jody Litfin. Since we focused on issue 1, I'll go ahead and start there as well. I don't think we had a disagreement on the standard of review here, and that's kind of what I think this discussion has been about. So I would agree that the defendant can claim inconsistent defenses, could have made this defense, and could have requested a defense of others instruction. But I think the focus that the state wants to point this court to is that it's the defendant's burden now, and we're at a clearly erroneous standard of review. So it's a high burden, and he must show, or she must show, that the court must be firmly convinced there is a real possibility that the jury would have rendered a different verdict had this instruction been given. And the state's position is that there's no real possibility that this verdict would have been given, or that they would have agreed that this was done in the defense of others. If we look at what the defendant has to present evidence of, there are a couple of things. One, that she sincerely and honestly believed that using force against another was necessary. And 2, that a reasonable person under the same circumstances, excuse me, would have also used force against the other person. So there's a subjective and objective prong here. And the state's position is that neither are met. And as Your Honor pointed out, there were kind of 2 pieces of evidence that the defendant focused on. And we don't believe that either piece of evidence shows her subjective belief. She didn't testify here at trial, so we have no direct evidence of what she was thinking or her subjective belief. And there's no evidence of anyone, none of the other witnesses directly discussed her intent as it concerned her daughter's safety as they were fighting on the ground. So we don't have that here. And the other pieces of evidence being witnesses heard her yell, "You won't jump my daughter," while the 2 women were fighting, and waving the gun around at the other witnesses. The state's position is that just shows that she didn't want other people joining in the fight. She wanted that fight to happen with those 2 on the ground and not to have her daughter get jumped by other women. That doesn't show that she sincerely and honestly believed that using force or shooting Vanity was necessary to defend her daughter. She was defending her daughter from other people possibly jumping in. And secondly, the testimony afterwards when they were in the van that, hey, we're all good, I made it stop, I shot up into the air. Again, that doesn't show that she sincerely and honestly believed that using force to shoot Vanity was necessary to defend her. That also may have supported the fact that she wanted the fight to end. And shooting a gun up in the air would have, that would certainly probably get the 2 women to stop fighting, but it didn't show her sincere and honest belief that shooting Vanity was necessary. And secondly, even if we do find that those 2 pieces of evidence, this court agrees, let's say that they do show her subjective intent. We have to look at whether a reasonable person in the same circumstances would have also used that force, and our position is that a reasonable person would not have. There were other things that she could have done. She could have gone inside the bar. She could have broken the fight, helped break the fight up, which I believe the other witnesses were testifying that's what they were trying to do, not join in the fight, but actually help break it up. Or she could have called law enforcement. She could have gone inside the bar and, got some other people's attention. Hey, there's a fight out here. But shooting into the air to break up the fight, or shooting 2 women on the ground who were in, close quarters, one being her daughter, and shooting that woman on the ground just doesn't seem objectively reasonable here. So our position is that under this standard of review, the defendant cannot meet his burden to show that this was error, let alone clearly erroneous not to give this instruction.
Counsel, does the evidence support that the defendant initially shot the gun into the air and up into the air and that didn't stop the fight. And so then she directed the shooting towards the person who was attacking her daughter?
Your Honor,
I mean, can you refresh me on the sequence of events?
I'm going to try to remember. I think I wrote, I mean, in the light most favorable to the state, which is how I wrote my facts. I want to say that there was at least one shot that was in the air, and then she was shooting at maybe other people and then shot Vanity. So I think this all happened within a very quick amount of time, but I thought that there was some evidence that the fight had been happening for 2 or 3 minutes and the women were basically done when the shooting started. That I could be misrepresenting. I mean, don't hold me to that because there were several viewpoints and I think the evidence came out differently among different witnesses. But that would be my recollection of, I think there was at least one shot where someone said she shot into the air and then began shooting around cars and around other people. So that would be my recollection, Your Honor. If there are no other questions, I don't believe I have any further presentation.
I wanted to ask you a question about the issue about the misstatement of state's counsel in closing.
Yes, Your Honor. The state did agree that there were 2 claims of error here for the prosecutorial error claim. One was the misstatement of fact and one was the misstatement of law. The state did agree that the prosecutor misstated the fact of everyone that you heard from testify that the only person that had a gun had a weapon that day was Misty. Because in reviewing closing argument, in reviewing the facts, there was testimony from, I believe it was the defendant's daughter, that she thought probably some of other women had weapons, but she didn't see any. And then she did testify that she got hit in the back of the head with a gun by one of the unknown males who she claimed had jumped into the fight. So we do agree that that was a misstatement of fact. As to the misstatement of law, our position is that the prosecutor's discussion of the lesser included offense of reckless aggravated battery was not a misstatement of law here, and the prosecutor did not equate accidental conduct with reckless. If we look in context to what the state's position is that she is arguing, and this was in rebuttal closing, so it was following what the defendant had argued. She's arguing that the evidence here supports a knowing aggravated battery, that the evidence does not support a reckless aggravated battery. She wasn't saying, hey, to find recklessness, all you have to do is found that she accidentally shot the gun up in the air. That wasn't what she argued. So I think if Your Honors look in context, this wasn't a misstatement of law. And despite being their misstatement of fact, this court can find that error to be harmless as well. And as far as harmlessness goes, we also have the jury instruction number 1, which told the jury, of course, that statements, arguments, remarks of counsel are not evidence, and that any statements that are not supported by the evidence should be disregarded. We presume that the jury followed those instructions, and the prosecutor did begin her closing argument by saying this. So she reiterated that first jury instruction as well. And if we look at the defendant's closing argument, she actually pointed out this misstatement of fact. So despite the fact that the prosecutor made that comment, the defendant's attorney reminded the jury of the daughter's testimony, saying that that the other woman probably had weapons even though she didn't see them, and that she was hit in the back of the head with a gun. So the defendant's attorney certainly pointed out that testimony and focused the jury on that testimony as well. The jury was instructed on the definition of recklessness, and both attorneys discussed the lesser included offense of recklessness versus the knowing aggravated battery. So we believe that for all of those reasons, and secondarily, the strength of the evidence, which the state believes showed that she knowingly shot Vanity on the ground. We believe that this court, even if, despite the misstatement of fact, and if this court determines that there was a misstatement of law, that both of those things can be harmless in this case. I believe I have any further presentation.
Well, thank you.
Thank you.
Appreciate your argument.
Just 2 points. First of all, I mean, my colleague notes that my client didn't testify here, and in the brief sort of really talks about how can we have any sort of information about the subjective belief of my client that might support a defense of another claim. Now, there's also, my client didn't make any statements about knowingly shooting any of it. We know that you can find evidence of culpable mental state from circumstantial evidence. And so, in fact, I don't have to prove anything beyond a reasonable doubt. I just have to have the jury form a reasonable doubt. So whatever level is required for sufficiency of the evidence, my quantum of evidence is less than that. And so the other thing about my colleague arguing is that, she says, when nobody's going to jump my daughter, maybe that was to keep the other women out of the fight. That's a reasonable interpretation, but that's not the standard of review. The standard of review for this part of this issue, whether it's factually appropriate, is in a light most favorable to my client. And in that case, then is it also reasonable to say she was saying, I'm defending my daughter? And we think the answer is yes. The last thing I wanted to say was just that my colleague points out that, well, she could have done other things. She could have gone back into the bar. She could have called the police or things like that. And they don't cite, and there is no law that says that if you are otherwise justified in using defense of another, that you have to use like the least restrictive means. That's not the Kansas law of defense, and we would ask that you would find as much. Thank you, Your Honor.
I have a question about the jury's verdict. Now, the jury had the option to convict Miss Lake of reckless aggravated battery, correct? Yeah. But they convicted her of knowing aggravated battery. How should we incorporate that in our analysis as to whether or not the jury would have reached or could have reached a different verdict if they'd been instructed differently?
On issue
Of other.
on defense of other.
Right.
I don't think it shows that this jury found, and we have issues about, like in issue 2, about the jury being misdirected about reckless, but assuming for a minute that that's a proper finding, then that has nothing to do with whether it was also proper and whether a jury could have formed a reasonable doubt. One or more jurors could have formed a reasonable doubt with regard to defense of another. Because in every case where there's defense of another, there's knowing use of force. Every case. So the finding of a jury in this case that the jury made that my client knowingly used force against Vanity in this case would have, that's why it's not inconsistent, would have no impact on that other finding. They could absolutely find that and also form a reasonable doubt that it was being done in order to protect her daughter. Thank you, Your Honor.
Thank you. We appreciate your arguments, and we'll try to get your opinion as soon as possible. This ends the oral argument for us this morning. Thank you for showing up, and this court will be adjourned.